an intense afternoon talking about serious legal issues, what better way to conclude than talking about tragedy? And that's what we're doing today. Also, from those who have seen my stream of travel talks, vlogs, over the past 18 months, you can see that I'm a bit of an amateur Graham Norton. Unfortunately, the panelists have stolen desk and I'm up here. So what we're going to do is we're going to speak to each three of our panelists for about 15 minutes each about their respective experiences. And before we do so, in terms of an introduction, we have Jennifer Lund, who's a partner at Irwin Mitchell's International Serious Injury Team. She has extensive experience for acting for those who have been injured and those who have died abroad. The trouble we might have today is, although she has extensive experience of what she can actually tell us about these cases, because so many of them have confidentiality clauses and have such sensitivity with all sorts of issues which we can only imagine what they concern. But Jennifer's going to give us a few nuggets with regards to what she's allowed to tell us. We have Mark Harvey, a doyen in the field of cross-law and personal injury law and product liability. I know you don't like being called that, out of your response on Twitter in the last April comment, but it's true, and it's a fair representation. If you want to feel inadequate about your practice or aspire to great things, have a look at Mark's website profile. He's been involved in such matters as Zeebrugge. I think I was 7 when that happened. The Clapham Rail disaster, a P&O lifeboat disaster in Cherbourg. He's been involved in hip replacement cases, the PIP breast implant cases. What he hasn't been involved in, quite simply, isn't worth being involved with. And finally, we have Thomas Ricard, who we are delighted to have visiting us in Manchester today. He's travelled from Paris. Again, Thomas requires very little introduction. He is the go-to expert on French law and personal injury litigation. If you want clear, honest, and accurate advice, not necessarily the advice that you want, but the advice that you need, Thomas is your man. So, without further ado, let's focus on to the matters in hand. And we're going to start with Jennifer. And to start off with Jennifer, as I said, there are some limitations with regards to what we can and can't discuss. But could we start off with you just telling us about an interesting case involving tragedy abroad and what is involved?
Yeah, absolutely. Well, firstly, before I get started, thank you so much, Ian, for inviting me to talk and everybody else at Outer Temple. I didn't realise I was going to be sat next to a doyen, so I've really good luck to live up to. So thanks very much for having me. Yeah, I was going to talk about the Inamenus case. It's a really fascinating case, but it's a devastating case. And what happened in this one was in January 2013, a group of about 32 really heavily armed terrorists, they attacked the Tigantarin gas facility, which is near the town of Inamenus on the Algerian and the Libyan border. And this group of Al-Qaeda affiliated terrorists, they managed to get hold of a load of weaponry from Libya following the downfall of Colonel Gaddafi. Really heavy weaponry, including surface-to-air missiles, rocket launchers, AK-47s. And they were able to smuggle it across the porous border and attack the gas facility. They pre-planned the attack. It was really, really well organised. They travelled overnight across the middle of the Sahara Desert in darkness. They avoided roads so as to avoid any sort of detection. And they launched a sort of tri-pronged attack on the gas facility. Now, the gas facility was a huge source of wealth for the Algerian government. So 5 o'clock in the morning, the main attack started on the entrance to the facility. There was a huge firefight where the security were based. There were a couple of buses exporting expats at the time and a huge firefight there, as I said. And then simultaneously, there was an attack on the central processing facility, which is where all of the gas, the natural gas, was processed and stored. And then at the same time, there was an attack on the Bastille. And that was the living area for all of the expat workers. So you can imagine waking up at 5 o'clock in the morning to shooting and terrorists screaming at you. And loads of people were killed in this firefight. A lot of people were captured, and others did manage to hide. And over the course of 4 days, about 800 people were captured. These were people from across the world, expat workers from across the world, and lots of Algerian nationals. And for those people at the Bastille, the expat workers, they were sat in a circle, their hands were bound behind their backs and Semtex bombs were put around their neck. And they were made to call their families, the media, loved ones, and tell them what was going on, and reiterate the demands of the terrorists. And it was absolutely horrific, you can imagine. Now, as all of this was going on, you can imagine governments from across the world, they were panicking, they were wondering what they were going to do. So you had Obama meeting with his team, you had Cameron meeting, having meetings in the cabinet office. And they were chatting to the Algerian head of state at the time to try and facilitate release of these hostages. But after 4 days, the Algerian head of state just decided they'd had enough. And they sent their special forces in the air. There were snipers in helicopters, there were gendarmes and military on the ground. And the terrorists at the Bastille, they panicked, they loaded up all of the hostages into 6 4x4s, and they drove at speed towards a central processing facility. And in the course of this massive firefight that ensued, some of the 4x4s rolled over, others were absolutely riddled with bullets, and many of those terrorists detonated their bombs. And over the 4 days, 39 expat workers were killed, 1 Algerian national was killed, and countless others were injured. And you can only imagine the families who were sat at home watching this going on. They could see these events unfolding before their eyes. It was on TV screens, it was in every newspaper you can imagine. So I can't really set the scene and show the pure devastation that was caused as a result of this attack. So I've got a little video.
Killed in cold blood. 7 British nationals and residents. 7 of the 40 men killed in In Amenas. The vast gas installation lies in the desert of southern Algeria. In mid-January 2 years ago, it was stormed by militants drawn from around the world linked to Al-Qaeda. Foreign workers were targeted. The Algerian army, which was supposed to provide security, poured reinforcements in. As the militants hunted for foreign workers, the army struck at them. And then, on the 3rd day of the attack, as the militants tried to destroy the plant, the army stormed it. Many questions remain, in particular about why the plant was so easily taken in a region that had become more and more insecure. The In Amenas installation was in southern Algeria, just next to the border with Libya. Security around In Amenas was maintained pretty successfully by the Algerian army. But all around the country, the security situation was shifting. To the east, Libya slipped into chaos. The border became near porous. And to the south, northern Mali fell under Islamist control in 2012. Across a stretch of North Africa, militants and their weapons were now moving freely. BP, one of the 3 operators of the plant, says that the attack was unprecedented. But the relatives of the men who were killed want answers.
There will not be a day that goes by that they do not think about what happened to their loved ones. So we need to be able to help those families understand why this happened, how it happened, and how these men ultimately how their lives were ended.
The inquest will not answer all the questions swirling around In Amenas, but it may go some way to helping relatives understand what happened to their loved ones in the Algerian desert. Johnny Diamond, BBC News.
So, Jennifer, as we will see in this clip, there was an inquest. What was your role in the inquest? What was the scope of the inquest?
So my role at the inquest is I represented some of the interested persons in the proceedings. And we always say interested persons, not parties, because it's supposed to be a non-adversarial process, but of course often it's not. So the first thing, I think you mentioned about the scope a little bit. What we did in this case is we wanted as wide a scope as possible. And that's the way that you can elicit the most facts, get the most witness evidence, get the most documentation that you're going to need to be able to support any subsequent civil claim.
Did you meet resistance in trying to approach it with broad scope from other interested parties who perhaps wanted a more narrow investigation?
I'm going to answer that question slightly differently. than how you've raised it in the way that I can.
Yes.
So what we did is, and in any inquest proceedings where you're trying to get hold of as much evidence as you can, as we looked at how we could widen the scope. And the best way to do that usually is to see if you can invoke Article 2 of the European Convention of Human Rights, because that widens the scope. So ordinarily, when you look at inquest proceedings, you look at who the deceased was and where, when, and how they died. And the how is really, it's basic in a normal inquest. So it's how the deceased met with their death. When you invoke Article 2, you can look at a broader scope. So in what broad circumstances the deceased met with their death. Sometimes when you're looking at invoking Article 2, there needs to be involvement of the state, and it has to be our state. It doesn't extend as far as a foreign state, but sometimes the coroner will be agreeable to extending that scope. So you can look at the broader circumstances in which someone met with their death. So rather than it simply be Mr. Smith sustained a catastrophic brain injury in a road traffic accident, you can look at the events that led up to that person's death. And then you can also look at matters such as the facts that were known, maybe about the risks that led up to that person's death as well. So obviously it's always in your best interest to get as wide a scope as possible throughout the course of the inquest proceedings.
And were you looking at the inquest as a means of gathering evidence for any future civil litigation? Or was it just to answer questions and get as much evidence as you could to answer those questions?
Yeah, absolutely. I think coronial proceedings are a really fantastic way to be able to get the evidence that you're going to need to be able to test what you've got for your civil claim, and just gather all of that evidence that you're going to need, because the coroner often has a lot more reach than you will. So if you've got inquest proceedings, use the coroner to help you get access to the documents that you wouldn't otherwise get access to, because in the same way as with civil proceedings, a coroner can compel witnesses to give evidence, she can compel disclosure. It's slightly difficult with deaths abroad, because a coroner can't investigate overseas. She can't compel foreign witnesses to give evidence, and she can't compel foreign disclosure, but she can use the mutual legal assistance process. So she will engage with her counterparts in a different state to use those courts to get the evidence that may be helpful. And she'll do that through an international letter of request. And I refer to her as a she, because I always refer to the coroner as a she for some reason. He or she, the coroner, can get hold of the information that way if need be. But I mean, one thing to be aware of is, however helpful or however friendly the foreign state may be, they're not always going to be agreeable to giving you that sort of information. So use the other interested persons in the proceedings to try to get the voluntary disclosure if you can.
And were there any particular challenging issues you had with getting particularly sensitive information, and whether or not the coroner could even look at that information? Is there any of those experiences that you had?
Again, generally speaking, rather than specifically speaking, yes, a really important point is going to be that in any inquest which involves any sort of sensitive governmental evidence, you are going to need to have a coroner in place who has developed vetting. So I think nowadays the coronial proceedings are more developed such that you're not going to find yourself in a scenario where you have a coroner who's not developed vetting. But there are ways and means of getting around that. And historically, what's happened is assistant coroners have been put in place to view sensitive material. And in fact, that is what happens in Manus. The initial coroner that was put in place didn't have developed vetting status. So they had to put in place the assistant coroner, who was actually the recorder of the City of London at the time.
So that's maybe a factor as you're approaching an inquest, maybe at the PIR stage, to consider, is your coroner sufficiently qualified or has the status to be able to deal with perhaps some of the issues that might arise?
Yeah, absolutely. I mean, it's not the easiest thing to stand up and make submissions to suggest that the coroner who's been put in place isn't the appropriate person to hear that. Unfortunately, ordinarily I'd instruct counsel, so they'd be the one saying that.
I was going to say, would it be counsel putting their tin hats on?
Yeah, absolutely, absolutely.
And what sort of labour lessons have you learned with regards to evidence gathering in foreign tragedy cases, whether or not it be in the inquest situation or in preparation for a civil case, perhaps the challenges of getting evidence from foreign sources. Have you got any sort of tips for the audience on good ways to approach it?
Yeah, I do. My team who are watching this at home, they hear me banging on and on and on about collateral disclosure and about large scaling disclosure. So I'm really sorry that I'm going to do that again, but I think it's really important. Collateral disclosure, it's something that we all deal with all the time, and it boggles my mind that there are so many people who don't appreciate what the rules are. But the CPR is really clear that if you get documents, you must only use those documents through the for the purpose of the proceedings in which they were disclosed. So if you get documents by way of criminal proceedings, in inquest proceedings, or even foreign proceedings, you need to check what permissions you have. And if you don't have permissions, you need to get them. Now, I've talked about the CPR rules earlier. There are 3 caveats to that. You can use those documents if you get permission of the presiding court. So if you get permission of the coroner to use them, or if you get the permission of a person who wrote the documents or disclosed the documents or gave that evidence, or if that document was read or referred to in a public hearing, then you can use them as well. But yes, that's the first point I would make. So always make sure that you get the permissions you need. The second point, this is where I get really excited. It's all about e-disclosure and metadata. So I know it's 4:20 in the afternoon and it's a bit dry, but for most of us in cross-border, when we talk about disclosure, we even in the most catastrophic high-value cases, we deal with standard disclosure, and a little bit we deal with specific disclosure. But when you deal with these really large-scale tragedy, and Mark will know this, for the first time you deal with this really large-scale e-disclosure, and you're confronted with hundreds of thousands, if not millions of documents. It's really, really overwhelming. So the key to dealing with it properly is effective planning really early on. And a lot of time you just really want to get stuck into the evidence. You want to get reading the documents, but you've got to take a step back and you've got to look at what documents you want to get and how you're going to get it. So when you're looking at the e-disclosure process, think about keyword searches. If you have an industry-specific accident, if it's a maritime accident, if it's product liability of a particular product, if it's oil and gas, learn the terminology, learn the lingo, and get to grips with it, and think about the keywords that you're going to search for, or ask the other side to search for in disclosure. Likewise, if there are key people that are involved in the case, or key places, think about how you're going to search for those things in disclosure. And by way of a live example, in the Inamena's case, there was one of the main perpetrators or planners of the attack it was a terrorist known as, his name was Mokhtar Belmokhtar. But back in the 1990s, he'd been injured in a firefight with the Algerian state and he'd lost an eye. And he was a really notorious narcotics and tobacco smuggler. So he was oftentimes referred to as One Eye or Marlborough Man in disclosure. So get to grips with that. Think about custodians of documents. Think about date ranges. Think about how you're going to batch and organise the documents. I often like to come up with the categories as they may well be pleaded in the particulars rather than doing something chronologically. And the final point I would mention is about metadata, really geeky disclosure stuff, but metadata. When we look at documents that are disclosed, we look at the physical document we see before us and the contents of it. Metadata is the information that is in the background of an electronic document. It's a digital footprint of all of the information behind the document. So it will show who created a document, it will show who modified a document, who it was sent from, to, all of that really useful information. So if part of your case is showing that a particular person or people knew about a risk and they've got a document that highlights a particular risk, then you can make or break your case with the metadata. So make sure that when you're getting that metadata, the documents, make sure the metadata remains intact, and you can speak to experts about how to be able to help you keep that metadata intact. And just a final example, I have, excuse me. Sorry, I'm getting so excited about metadata that I need to have a drink. in the past, I have seen, maybe inadvertently, I'm not sure, metadata being lost when parties have effectively disclosed evidence. But what they've done is they've printed off documents and then they've sought to scan them back in as a PDF and then disclose them. So all of that really vital metadata is lost.
It's hard to say that I could probably talk about metadata for hours more. I have lost trials on metadata, and I remember being in a very, very sticky situation in the trial, only for the original photograph to be distributed to everybody. And we did find out the accident did happen on the day that my client said it was happening, and I managed to get out of it and win. So it can be very important.
There you go.
Thomas, moving on to you. Now, I first became aware that Thomas was involved in the Bataclan litigation in France when he sent a link to a Guardian article in which he happened to be quoted to a group, WhatsApp group that I'm in. And I've revisited that article this morning, and Thomas, it says in the Guardian, acts for a large number of Bataclan theatre survivors from the UK and Ireland. And Thomas, would you please share with us a little bit of what it involves? And I'd like to know in particular the snazzy court that has been built for these proceedings.
Yes, thanks Ian, thanks to Outer Temple, thanks to Paul Sarah and Joe McDermott for having me. It's a dramatic subject I'm supposed to talk about. You will excuse me if sometimes I take it a bit lightly. It's my third time in Manchester. The first time I was 17 doing a summer job at the Automobile Association. The last time the Spice Girls were playing on a reunion tour, and the third time is today. So I think I'm on a glamorous path. The Bataclan is, and technically, the journalists are making a mistake. It's not the Bataclan trial. It's the 13th November, because people forget there were 3 other attacks, 2 in the streets of Paris, 1 at the Stade de France. It is by any means an extraordinary trial, but I would say from procedural point of view, unfortunately, it's not, I would say, the most interesting one, because we're not getting the answers we want, because the people who are on trial are not the major figures. But it's a first in France. We've got 1,768 victims registered, which includes indirect victims. There are 130 people who died, and about 90 of them in the Bataclan. There's about 30 UK nationals. We represent all of them but one. And it raised particular challenges, which are technical challenges, but also challenges that highlighted how difficult the French system could be, which also, and that's the positive side, has led to some positive changes. The attacks happened, and then we had a 5-year investigation. The prosecutor and the investigating magistrate were instructed to investigate on terror charges. It is relevant because I know you have the Manchester bombing, for example, with other aspects of the trial, such as the safety of the premises, the training of the security staff. And this is one thing that was a little bit frustrating, because the investigating magistrate in France could only investigate on what the prosecutor asked them to investigate on, which are the terror offenses. So all the issue with the security of the staff, the security of the site, for example, was left out.
For us, in terms of the scope, we have coronial inquest here, which is to find out who, how, why. We have the criminal section penalising the civil action. Is this all a bit of everything, or is it just an inquiry?
It is indeed a little bit of everything. We had a 5-year investigation. At the end of the investigation, the investigating magistrate decided to send roughly 15 persons for trial. Now we've got a 9-month trial that takes place Tuesday to Friday, 12 p.m. to 8 p.m., 9 p.m. when we finish. It's made so that the accused do not get too exhausted. But we had very pragmatic difficulties. For the UK nationals, for example, what are they supposed to do? Attend the trial for 9 months? It's not possible. Then the French had a genius idea to say, no problem, we're going to do a web radio. So you could actually listen to the trial at home on your MP3 player with a secure system. The idea sounds good, then comes the practice. You can't access it outside France. So that's what they realized 3 weeks before the trial. Fortunately, they'll be able, the UK nationals, to go to the local consulate, it should be available in next weeks, to go and listen to this at home. That's when we as lawyers got a little bit upset, saying, it's the first time this happens, there should be some protection, some support, because you can't just go at home and hear Salah Abdeslam, who's the only survivor of the attacks, talk about how he planned to bomb the Bataclan. It's very difficult for them. For the next trial that's going to be at this scale, which is Nice, the Ministry of Justice, who was, I would say, quite attentive. We had several meetings with him. He basically said, we know there are difficulties and they are taking those into consideration. The picture I wanted to show is the court they had to build. It is inside the old Palais de Justice, and it's basically a city sort of train station. So if you want to get the picture, and inside this, they decided to do to build a court. It was, I would say, a first and a success because the court works really well. The problem you have is, for example, in terms of it's very, very practical problems. You get into the court, you're going to have the jury, which are professional judges, the accused in a box, except 3 of them who are on bail, who come every morning. On the left, on the right, you've got the victim's lawyer, and then you've got all the rows with the victims. You don't have enough rooms for the lawyers. So you've got the lawyers next with the victims and some defense lawyer next with the victims. As you can imagine, you can have sometimes the victim saying, can you please stop typing on the computer? You need to listen to this testimony, but out of respect. It creates emotional situation which we are not anticipated in this case. You were asking Ian about how does it go with the civil compensation?
Yes.
It goes at the same time for the last year, and it was a long process. We had the Fond Guarantee, the compensation fund, who is involved to provide some sort of compensation. The first hurdle we had was how do we do it? So we had some experts.
So is this the same form to guarantee that we would see?
Roughly the same, exactly. Except that this time it was a sort of court-sanctioned scheme, and the legal expert, the medical experts, sorry, who would instruct, are technically not allowed to proceed outside France. So we found, I think everybody had to be a little pragmatic because we said you can't ask the victims who have not been in Paris for the last 2 years to come back to Paris for this. Everyone was a little bit pragmatic, and coming back to this issue of where the trial was supposed to take place, if you look at some sort of parliamentary debate on where the court was going to be built, some deputies suggested that the hearing should take place in the Bataclan Hall. So we explained that that would be slightly traumatic for victims to come back for the trial where the attacks happened. The process was very long for those expertise because they took place in London and in Ireland, in Dublin. You can imagine how difficult the process is for them because we had to explain the French process, which is I would say less confrontational, but quite difficult.
So did the witnesses give their evidence remotely? Did any return to Paris?
So that is one thing that was quite beautiful, is that it creates this sort of solidarity between them. So there is a lot of charities involved, and they were able to come back to Paris, I would say, within, in a bubble that makes things more tolerable. And then there are two things that happen. Because you have to understand, being, I think, outside the country, those UK nationals had a sense of distance with Paris, like it didn't really happen. You know, you could see Paris the week after the attacks. I think it's part of the grieving process that everyone was so affected. In the case of a couple, a lovely couple, they went to the Bataclan. Before that, they had 5 or 6 pints. They spent half an hour, horrible half an hour there. They managed to get out. Their clothes are drained in blood. They change the clothes. They go straight to the airport, and at 4 o'clock, they get the first flight back to the UK. They're back at home at 10 o'clock in the morning, thinking, did that really happen? And I think part of the two things that have been, I think, very, very important for them is how they testified. They were allocated basically 2 days for UK victims to testify. We were able to go with them. And it creates something that was quite unexpected. I shouldn't say that, but a lot of UK victims wanted to testify compared to the French one in terms of proportion. The fact that they testified and the fact that they gave such a moving and coherent testimony, I think the Brits were very noble in the way they spoke, and it really moved the courts, and it led to a lot of other people wanting to testify. So now we're going to have another month of victim testimony before the submissions in May. It surprised the court, but those 20 or so UK nationals that went to testify created something very unique. It was with a translator, but I would say we had a sort of agreement with the defense lawyer not to cross-examine, except if one of the victims was really going to challenge the storyline. But it made things, because the defense lawyers are lawyers that we know. Sometimes me, I acted on the other side. So we had a sort of agreement in that respect. The second point, and sorry to be a bit technical, not as I'm not going to be as excited as you speak about metadata, but I'm going to come to this point actually, is for the first time in France, there is a change in the order of questioning. The usual order is the president asks the questions, then the victim's lawyer, then the prosecutor, then the defense lawyer. It creates, in cases like that, something ridiculous where the victim's lawyer is going to start asking questions for 2 days, and then it's up to the prosecutor. The accused is exhausted, and he loses the why of why he's accused. We pleaded for this. Some victims' lawyers were not happy at all. We asked for the order to be reversed. It's the prosecutor who speaks before us. And it's the first time in a trial like that it happens. It leads to a shortening of the questions by victim's lawyer. So that's why some victims are very unhappy about that. One of them from POP, great lawyer, but we really argued against him on this because I don't think it's my job. I think it's the prosecutor's job, but that's one thing. The compensation, and then I'm going to just come back to the last point because I don't want to run over time. The last point I wanted to mention, and that's something we discussed with Ian just before, is evidence. Because I know Jennifer, it's a hobby. The evidence is battlefield or military produced evidence. We had a week of arguments on this, quite fascinating. Basically, the issue they had is US military in particular picks up evidence on the battlefield, creates a sort of data center, puts it in. How can we use it? It's produced outside any formal legal context in France. And we're not talking about documents that may have been doctored and things like that. In this case, we've got one of the accused is in the box, Pakistani national, says, I don't know why I'm here. Suddenly, the US military provided the video of him, close to 5 high-ranking ISIS terrorists. And the issue was, what do you do with this? I mean, once it's been produced, and the French are a lot less sophisticated than the Brits on this. We do not have a law on evidence. When I studied in the UK, I know there was a book, Evidence. I was like, oh, I felt like the ape in 2001. I was like, we have this, we must exist. It's an access to a Platonician truth. That's a debate we had for 1 week. We think it's going to be admissible, but that really raises this important challenge. The conclusion I have is we actually took, when preparing the trial, we looked a lot at how it was done in the UK, because we don't have things on such scale. So thanks for this, because we really looked at how you have dealt with impact statements, how you deal with treatment of so many cases. Finally, in terms of expectation, I think that's the only positive things our firms truly did was to lower the expectation of the victim, saying in terms of truth, you're not going to get a lot of answers, but I think they're all happy to have gone through this process.
Well, I know to get you an evidence textbook for Richard's present, Thomas. We can continue talking about the nuances of evidence, Thomas, but instead we're going to talk about evidence with Mark. Now, we are, to an extent. Mark, when you're dealing with product liability cases, say PIP cases or the HIP cases and the like, you're obviously dealing with so many people who've been affected by it, and you're not the only law firm who's dealing with the particular cases. You've got other lawyers and hoping that they behave yourself. And in the notes that you sent me, I can see that you've had experiences where they don't necessarily play along as they should do. When you're starting off on a case like this, maybe if we look at the breast implant cases to start off with, what considerations do you take on board in identifying who you might sue, when you might sue, and what you're going to sue them for?
First of all, thank you very much, Ian and Paul, and your colleagues, for inviting me. It's a real honour. It's particularly an honour when I look around the room, rather awe-inspiring, seeing a whole galaxy of firms who are just brilliant in this field, and to share my experience is a bit awe-inspiring. PIP, the PIP group litigation, the breast implants, probably is a good idea to show where. And you guys do this all the time, and some of the talks this afternoon are similar about where's your remedy, what's the quickest way. For those of you who may not know, I think most do, PIP was a French company down in the south of France that was making breast implants, silicone breast implants. Unfortunately, the owner decided to cut corners and save cost. And so he used non-medical silicone most of the time. When he knew he was being audited, he would bring in the proper silicone. So there are some PIP implants out there that are kosher, but most of them unfortunately are just, as they described it, as mattress filler. And so this cost cutting, eventually the French health authorities raided the factory, and we had the unusual situation, the first time in all the product cases I've dealt with, where we had the manufacturer admitting they'd made dodgy products because they pleaded guilty right from the start. We'd been involved quite early on. A group of women had come to me from Newcastle, who all had these implants go wrong early on. Their surgeon actually had sent them to me and said, these don't look like any implants I've ever explanted before. And we just thought it was a batch issue. Any of you who've ever done product liability know sometimes the process goes wrong, they leave them in the oven too long or something. Because what we discovered eventually was a massive fraud. And the problem then was that sadly a French woman died of breast cancer, allegedly linked to the PIP. And this story came out around about Christmas week. So the British press went mad, had a field day, and we just had hundreds, if not thousands, of women coming forward who'd had these implants. What came with that challenge was that it also came with it, as you've alluded to, dozens, if not hundreds of law firms. Very few as experienced as you guys. A lot of them claims farmers in those days were selling cases to them and saying, these are simple cases. We know these implants are rubbish, straightforward cases. And I had to spend a lot of time. I brought a steering committee together quite quickly of 3 or 4 firms who are in the room today, experienced colleagues who this sort of work, because we needed to take control of the cases quickly. We knew that there were people issuing cases in local courts, and they were all arguing Consumer Protection Act, defective products. ignoring the fact that the manufacturer effectively went into liquidation quite quickly, had no insurance. And so we had to find remedies, and that's when we looked at some of the things we've talked about today. Consumer contract remedies, the old sale of goods, supply of goods and services, things I learned at law school all those years ago. Consumer Credit Act, again, used regularly, of course, you guys use it, where we'd sue the funders. So from the start, it was, what's the appropriate remedy? Who are the deep-pocketed defendants? Because there were literally dozens of clinics that went bust within a short period of time, who had no insurance, no assets. We even got into insolvency work. We took assignments and went and sued their suppliers. And then the other big challenge was the solicitors and the clients. Now, a lot of you who do these group actions will know that managing expectations is probably more of a challenge in a group action is than managing your unitary client, because they all talk to each other. And it's very difficult, and all our letters go out in all of our group actions, big bold letters, do not reproduce this information, it is private, it is confidential. What you probably don't expect is when one of your solicitors, one of the outside firms, actually takes some of your confidential advice and put it on a website, because they thought they were being very clever, had a website for their clients. We only had one concern in the whole case. There was an argument about limitation based around the so-called worried wells. So the women who didn't have ruptures, understandably, did not want these implants inside of them. Big question mark as to whether that's a personal injury or not. Do you get 3 years because it's a personal injury, or is it 6 years with no date of knowledge? So this solicitor decided to reproduce our advice, warning of the problems on their website, which thankfully we found out quite quickly. So managing expectations and controlling the information, we've always worked on the basis, every group action we've ever done, and we do a lot, that anything we're telling our clients is probably being read by our opponents, unfortunately. And we've had many occasions.
And in terms of setting up the steering committee and giving the case direction, was that a relatively straightforward process to start off with, maybe with some of the more well-known firms? Was it a little bit more tricky with some of the claims farms and some of the smaller firms that were getting involved?
Yeah, I mean, fortunately, I had pals like now retired David Bodie, Moe and Mitchell, who I've done group actions with for years. Slater and Gordon, Richard Langton, now retired. They're all retired. I don't know why I'm still here. But could have something with my divorce a couple of years ago. But so I was able to go to them. They had cases and said, look, we need to get this together. The claims farmers were a problem. So were there one or two high-profile firms that don't take kindly to group actions and steering committees. We had one or two firms who kept writing letters to all the solicitors challenging what we did, embarrassing themselves because this was a contractual claim. They want to know why we weren't suing the NHS and there's no contract. So we had some challenges like that. We did have Slater and Gordon very kindly hosted a meeting in their smart offices in Chancery Lane, where they had lots of TV screens, which in those days was, pre-pandemic, was quite new. And we had offices dotted around the country where we talked to outside solicitors and explained what we did. And 99% of them were happy to be led and steered by us. And for them, for a lot of them, it's because we actually gave them remedies they didn't know existed. So they all came in thinking, this is a defective product, I can sue the manufacturer. And then when it was pointed out that wasn't available and their AT insurers didn't want to support them, we were able to introduce them to other remedies.
And when you're dealing with that many claimants, do you ever get into a situation where conflicts can arise between interests of claimants that you're acting for? And if so, how do you deal with that?
I think one of the things that people don't often appreciate from group actions is just how many potential areas there are for conflict. Your duty is to your client. Now, it doesn't matter whether there's one of them, 10 of them, 1,000 of them. Your duty is equal to all of them. And in certain cases, you do have problems where one sort of circumstances might help one group, but it goes against another. I know there are people in this room, for instance, who are involved in air crash cases, and I've often been brought in because of my product liability dimension to come into groups of lawyers from different jurisdictions who are representing people on the same aircraft, the same helicopter. And you start by thinking, we need to show how this helicopter crashed. Is there more insurance available through the employer or the manufacturer or the airline, etc.? But that can then lead you into tensions between the damages that might be awarded in different jurisdictions, depending where you go. And I've been involved in a couple where I've had to explain. There was a case we did, can't go into too much detail, but it was a transport disaster. And the lawyer who brought us all together, I was representing one particular client from Britain, who, because of the way the law worked and because of the Hague Convention that relates to France in products, actually we were going to get proper damages, proper damages that would put this widow back into the position, she would be under the law of England, Wales, Scotland, etc. But the defendants actually objected, so we turned up for the meeting to negotiate, and they actually excluded the steering committee, the chairman, who brought this together from another jurisdiction, because he was representing others where they were going to have a different outcome. And it raised some quite challenging conflicts there. But you do have to be very careful, because you cannot overlook the fact that your client is the same one, whether there's 100 of them or one of them. And that is something I often have to explain to other solicitors who don't do many group actions who get involved, that you have to be careful that you don't find yourself in a position where one is against the other. And it's an issue I've had with defendants, because there's a buggeration factor, I understand, for defendants thinking, we're just going to give you a sum of money, you go and sort it out. And that's perfectly legitimate, but in certain cases, it actually becomes an unacceptable offer. You simply can't deal with it, because it might be, we saw it with implants, we saw it with hips. I remember a group action that we had, and we went for the GLO at the request of the defendant on that occasion, and they wanted all these cases bringing in, but they didn't fit our case plan, what we thought was a defective product. And we were saying, well, if you bring those in, and we're going to lose, because we know they don't have the problem that these have, we'll end up with cost sharing issues. And if the defendant said, well, we're going to give you X pounds to divide, well, then it becomes very problematic, because these group of claimants have a very strong chance of winning. These group of claimants have a very poor chance of winning. This obviously doesn't happen in transport accidents, it happens in product liability. And you've got a real problem then. And you sometimes have to say to the defendant, well, you're going to make this such that we can't settle anything. So I'm afraid, group actions are very attractive and glamorous. They also give you sleepless nights. Or as my wife will tell you, it's not a sleepless night, it's just I talk in my sleep, the more stressed I am. But those are the sort of things that we forget about most of the time, but they crop up in group actions a lot.
Thank you, Mark. I've got a long list of questions. We could stay here all evening with me peppering the panel with questions, but does anybody in the audience have any questions, whether or not it be how to approach evidence gathering, group actions, top tips, or anything else? Well, you've got an opportunity to ask. Or Thomas, why he likes evidence quite so much as he does. Do we have any questions? Oh, Daniel Latchet.
Metadata.
Could you speak as loud as you
Thanks,
possibly
thanks,
can?
thanks,
So
thanks,
online
Dan.
can hear you.
Sorry, I'll shout out for that. Yeah. It was just, you mentioned about the probably coincidental or entirely good-natured attempts maybe to circumvent metadata by scanning in photocopies, etc. Do you seek particular directions to avoid that? If so, how robustly are they opposed?
Yeah, for those at home who didn't hear Dan call me a geek, but I'll accept that gladly. So thanks, Dan. Yes, actually, at Practice Direction 31 of the CPR, there is an electronic documents questionnaire. And if you get hold of that really early on in the proceedings, one of the key things states what you're looking for in terms of disclosure custodians, but there's also a section where you can outline the metadata that you're seeking. So if you have those discussions with your opposite number really early on, you can make it very clear what you're seeking. But also as well, as soon as you're aware of the fact that you are likely to be bringing a civil claim, you should be putting the other side on notice of that fact, and you should be making them aware. I mean, they should already be aware, but you should be making them aware of the fact that if they have some sort of automatic document disposal policy, that they need to disengage that, if you like, so that anything that otherwise would be automatically deleted is retained and kept safe somewhere with all of the metadata intact for the purposes of disclosure throughout the coronial proceedings of the civil claim. I didn't plant Dan with that, even though from Owen, it's not a plant.
So can I thank you all, both of those who are here, and those who are, where is the camera? Over there, thank you. I just, hello. I do exist. For attending. Manchester has been my adopted home since 2004, so it's great to see quite so many people from the Manchester end of the profession here, which of course does have such a strong travel law presence, but also thank you for those who've travelled from further beyond. And thank you to all of those who have attended via Zoom, who I believe are international as well. So thank you very much to all of you. There's not really much I can say other than thank you for attending, thank you for listening, and thank you ever so much for the speakers within chambers. We don't usually thank ourselves. It does take a lot of time. Fortunately, the preparation for my section only took a couple of hours, and having a few nice chats with people I like. For those who did the proper talks, I appreciate that involves an awful lot of work, so thank you very much for your efforts. And even more thanks to our guest speakers, Colin, Jennifer, Mark, and Thomas, for travelling here and sharing your knowledge with us as well. So in terms of the broadcast, I'm going to say goodbye to Zoom. And